No contract, no signed agreement or application. This is part 3 of the video series that accompanies the 3 weaknesses most debt collectors have report. Brought to you by yourlegallegup.com, your advantage if you are being sued by debt collectors. As we've said before, debt buyers purchase debts in very large quantities. They buy them for very small amounts of money, and they bring lawsuits in bulk. These practices create weaknesses, and 2 of them we've already discussed: that they don't bother with the bill of sale or chain of title, and that they can't authenticate the records of the supposed debt. The third weakness that most debt collectors have is that they do not have initial contracts, offers, applications, or other documents showing the intent of the parties to form a contract or the terms of any such contract. In an action to collect a debt, the plaintiff bears the burden of proving the existence of the debt and that the debtor is indebted to the creditor in a certain amount. It also includes all the terms of the agreement, including the agreement to repay. Here's the basic law. When a credit card company issues a card, it's extending a line of credit to the consumer. When the consumer uses the card, he or she is agreeing to pay the money back at that time according to the terms of the agreement. Debt collectors can't show the terms of the agreement. Furthermore, if each transaction is a separate contract, then proving a breach of contract requires proving the underlying transaction that created the contract, the use of the card, in other words. Generic terms not shown to apply specifically to your contract are not enough. So a lot of times debt collectors will simply attach, general terms of the agreement that aren't connected to your credit card, and they'll claim that you agreed to those, but they're not attached to your contract. The courts have found that those are not good enough. Debt collectors can essentially never attach credit card statements showing the purchases, because in most cases they have only a few of the credit card statements. Often, statements that don't show a single transaction, one of their favorite things to do is to show the statement at charge-off, which is when they've long since stopped extending money to the person who is using it. And so obviously there's no purchase there on those statements. It just shows money owed. Now, you should remember that seeking interest or fees without a contract is a violation of the FDCPA. So when you discover, through your discovery, that the debt collector is suing you for amounts that include interest or fees, and they don't have a contract, or they can't differentiate what amount of the debt is principal and what is interest or fees, then you can counterclaim under the FDCPA for seeking money unsupported by the contract. We go through this in detail in the report below. Account stated. Now, aware of the problems created by suing for breach of contract, many debt collectors and even original creditors sue you under another basis called account stated. That's a different kind of claim for essentially the same money. It's a different way of putting it, with a different set of laws attached to the same money. If they won both of them against you, for example, they could only collect once, but they do have to prove different things under each theory. They will say in their petition that they, or the original creditor, sent you statements, that you didn't object, and that therefore you agreed to the amount stated in the statements. That's the account stated. But they can't prove the statements were sent to you because they can't authenticate the original creditor's records. Account stated is a claim for a specific amount, but no other terms of the implied contract or promise are included. If anybody has added fees or interest other than what state law provides to the final amount, then it is sought an amount not supported by the contract and is in violation of the FDCPA. In other words, if there's been a charge-off and the debt collector decides to add fees or penalties to that last amount that got charged off and then to claim under account stated, then they're adding fees or interest that are not supported by any contract and would be in violation of the FDCPA. Debt collectors essentially never have more than a few statements. Again, this goes back to the way they do this, all in bulk. They don't want to, hoard gigantic amounts of statements, so they only ever have a few. The statements are often generated by the computer and aren't properly authenticated. They should be laughed out of court, but they won't be. You'll have to make the arguments. Further, all the records of the debt collectors will be hearsay anyway. As I said, they can't authenticate these records. The law of account stated was designed for people with running accounts like bar tabs or hardware store running tabs, where the total is figured up and payment asked for at the end. This is obviously not appropriate for debt collectors, especially with credit cards. They never have any relationship with the people that they eventually sue, and it isn't, as I say, it's not really appropriate for credit card users in general, because credit card users aren't looking at their accounts. The account stated theory rests on the belief that people will know and remember the charges that are made against them. They'll look at them in relation to the statement sent and will haggle over any disagreements. But the statistics show very clearly that this is not the way people with credit card balances act. And therefore, many states require some indication that there was, in fact, a separate form of agreement, some other kind of agreement or indication of agreement, that some of this stuff, did happen. And debt collectors obviously can't show any of that. But many states don't actually have that requirement. So in California, for example, they are willing to believe that if you received the statement and didn't disagree with it, and it was a credit card statement, you didn't disagree with it, that you may have an account stated. However, again, remember that the records that for debt collectors, this is a problem debt collectors really have, is they can't show that you received or even that anybody sent the credit card statements. So that's what I just said. Debt collectors can't show any evidence that the statements were sent to the defendant. We run you through the arguments below, and we give you case authority to get the court's attention. And again, we remind you to look at the case descriptions in the report. I already said this earlier, that all of the cases that are cited in the report have, in parentheses, little notes about the decision and what the court held. You should look at all of those cases and see which ones apply to you and to your case as you prepare to argue wherever you happen to be in the matter. You're going to want to put those cases together. If you don't find in the report a case from your jurisdiction on a specific issue, well, then you could do a search. You could do a Google search or some other kind of legal research search to find a case in your jurisdiction that does give you that authority. That's a more powerful way to go. Protect what's yours and don't let the debt collectors rip you off. yourlegalega.com